Real Estate Problems into Profits is hosted by me, Andrew Weltchek, a partner at Cohen Hochman Allen, attorneys at law in New York City. In every episode, I interview other real estate professionals, including realtors, brokers, attorneys, investors, and developers of commercial, mixed-use, and multi-use residential properties. And together we provide insights into real estate law. You can find this show on www.chalegalteam.com and on YouTube, LinkedIn, Apple Podcasts, Spotify, Google Podcasts, and more. Now, here I am, the host of Real Estate Problems into Profits, Andrew Weltchek. Thank you. Hello, everyone out there in online video land. This is Andrew Weltchek, as you just heard, with my good friend and guest, Hal Coopersmith of Coopersmith and Coopersmith, a leading landlord and tenant legal firm in New York City. Third generation, right, Hal?
Third generation, that's correct.
All right. Well, that is something to be proud of. For the rest, to start off with, tell us a little bit about what it means to be both a landlord and a tenant lawyer, and a both commercial and residential lawyer.
Right. And just to clarify, we're a transactional law firm at this moment, not necessarily litigation. And
you don't evict people.
Correct. We don't evict people or businesses. And you're correct, Andy, that we practice residential and commercial law. So we'll work through residential purchases and sales, commercial purchases and sales, commercial leasing, and also residential leasing. And if you think that residential leasing is a pretty straightforward aspect, I'm here to tell you that it is not.
Well, you have a special program for helping landlords with that, right?
Right. So in 2019, New York State passed the Housing Stability and Tenant Protection Act. And this was a sweeping reform of residential leasing laws. It affected rent-stabilized units. It also affected free market units. And when this law was enacted in 2019, it imposed a lot of requirements on free market units, something that a residential landlord had never seen before. Deadline, even if you're renting out one house or one apartment in New York City, you're subject to the law, and a lot of people aren't necessarily aware of them. These requirements include sending out a rent increase notice, a notice of non-renewal, offering the tenant a walkthrough, and returning the security deposit within a certain period of time. And we saw that this law was passed in 2019 and that there was going to be a lot of requirements. Of course, in 2020, there was the pandemic and there wasn't really a formal rental season. 2021, we saw the market rebound a little bit. 2022, the market was on fire. But to your point, Andy, we've developed a proprietary platform that helps landlords, even the individual investor, the pied-à-terre owner, follow these deadlines they're not necessarily aware of. And it became a big issue 2 years ago in the summer of 2021 when there was a $5 million house in the Hamptons that had their closing delayed because the tenant, who is an executive at Cantor Fitzgerald, said he didn't receive the notice of non-renewal and stayed beyond the length of the lease, causing a lot of litigation.
Which they could afford, unlike most people.
Yes. The point being, if you think that these laws are going to be taken advantage of by lower level tenants, or it doesn't necessarily affect you, this was a single family high-end property in the Hamptons. And as I say, if it can happen to a $5 million house in the Hamptons, it can certainly happen to any property in New York State. And so like I said, we developed a proprietary platform called ResQ. It sends out emails and text messages reminding an owner, reminding a property manager, reminding a broker what they have to do by when. And as people have become more conscious of the law and these requirements, people are really loving ResQ. It provides the reminders that they need. It calculates the deadlines. and ensures that a timely notice of non-renewal is sent. So, for example, if you're in a co-op apartment or a condo apartment and there's a limitation on how long you can lease out the property, and you don't send out a non-renewal notice, that tenant could, in theory, stay beyond the length of the lease. And that owner is subject to penalties by the co-op or condo. So it's really important that a notice of non-renewal is appropriately issued to avoid these sorts of consequences. And we are preaching that as much as possible to say a residential lease isn't just a revenue form of lease anymore. There are significant consequences if you're not aware of the law.
I'm sorry, I just had to look at a phone that was buzzing. Isn't that the way life is nowadays? But the lesson here of rescue is that you need rescue. That is to say, otherwise you could be in deep trouble. But it can help you take care of the nitty-gritty details.
That is the message of rescue, is that you need rescue. We're certainly trying to preach the requirements of the law and that this is a solution. So calendaring the deadlines. What we've seen is that people have spreadsheets that they don't necessarily update, that they think it's someone else's problem, that it could be the building's problem, the building thinks it's the owner's problem, broker thinks it's the owner's problem, the owner thinks it's the broker or the lawyer's problem. No one's really stepped up to fill the gap. Rescue does that. It's automatic. It's simple. We didn't really talk about this, but I think in honor of this podcast, we'll offer a free use using the code Weltchek to anyone who signs up, who's listened to this podcast.
And to be clear, I don't get any piece of that. It's all for you. And I'm grateful. I'm happy for you and your customers, your clients.
It would all be free. And it's at rescueme.com, REZCUEME.com. It takes less than 2 minutes to sign up and enter code Weltchek at checkout. And it's free for use.
And they can also get an access to it at coopersmithlaw.com, right?
Correct. It's also on our website. There's a link
right.
to it.
Let's talk a little bit about
Coopersmith.law.
Excuse me, Coopersmith.law. Another clever point, everybody thinks .com is all there is to it, but Hal knows better. There's many extensions that make clear what your business is. Coopersmith.law. How much clearer could you get? Now, let's talk a little bit about the other kind of tenants, people who have stores, commercial tenants. What comparable kind of help can you provide them?
Sure. So I think there's a couple of timely issues, pre-pandemic and post-pandemic, at least in terms of talking about commercial tenants. So one of the things that we saw during the pandemic, particularly with respect to commercial leases, is percentage rents. And a lot of stores were put on percentage rent deals, or certainly part of shopping centers when volume wasn't as high and landlords wanted to retain those.
Hold on. Tell the civilians exactly what is meant by percentage rents.
Sure. So a percentage rent, very good question. A percentage rent is that a tenant pays a percentage of a sale to the landlord as their rent. And
the landlord gets to look into the cash register?
A landlord gets to look into the cash register.
And they trust you?
You seem shocked by this, Andy.
I'm acting as if I didn't know what I was talking about, which is easy sometimes. But your point is that this is entirely different than the kind of residential rent where you pay a certain amount every month and that's all she wrote. Here you've got a business in the place, and the idea, presumably, is that a percentage rent is fair to both parties, because if you make so much this month, you go so much to your landlord. If you make so much next month and it's different, you owe the different percentage, the same percentage, but a different absolute amount to your landlord, and everybody's happy, hopefully.
That's right. And there are a couple of situations where a percentage rent would work, or is certainly implied. One was we saw a lot of it increase during the pandemic. And as we talked about, a shopping center volume was reduced because people weren't as out and about and quarantining. Landlords converted a lot of rents to percentage rents. Say, we understand that you can't afford this fixed rent that we agreed on before the pandemic. We'll look into your cash register, to your point, Andy, and you can pay a percentage of what your sales are. That's one aspect. Another aspect is, as a part of shopping centers to encourage business, you could have something like a hybrid where there's part fixed rent and part percentage rent. And there's certainly, I know, a food hall across the street from our office where every tenant is on a percentage rent, and they're all looking inside the cash register. The reason why I bring up a percentage rent and looking inside the cash register is that there are certain accepted practices for reducing a percentage rent, and that landlords accept that these items reduce a percentage rent. So it's not every dollar you sell that there's a percentage rent, that there are certain deductions for what a percentage rent is. Those can include state taxes, so sales taxes, easily a given. If there's $1.10 of a sale and 10 cents is taxes, just to make the math simple, then those taxes shouldn't be paid to the landlord. A percentage of those taxes shouldn't be paid to the landlord. Similarly, if there are credit card processing fees, landlords generally accept that to be deducted from percentage rents. Gratuities to staff, landlords generally accept are excluded from percentage rents. Gift certificates, until they're redeemed, are generally accepted to be deducted from percentage rents. And promotional items, either to third parties or to staff, to comp someone up to a certain amount, are generally also excluded from percentage rent. And the reason why I bring this up is twofold. One item which we found during and after the pandemic is that some tenants didn't have these deductions from their percentage rents. So in their lease, no one thought to deduct these generally accepted items from their percentage rents. And that's certainly a flaw, at least in terms of a lease and a tenant negotiation. Certainly when we represent a landlord and there's a percentage rent, we understand that there are these deductions, and other landlords understand that as well. But tenants, at least in terms of their representation, should understand that there are generally accepted deductions from percentage rent. So that's the first item. The second item is that if a tenant had these deductions from their percentage rents, that they weren't necessarily taking those deductions. And a service like Shopify will display a net sales. And a net sales on Shopify is a net sale after deduction of a state sales tax. But it doesn't represent a deduction after the items that I said, credit card processing fees. I'm not sure that it represents gratuities either. Gift certificates until they're redeemed, promotional items. So it's important to recognize that even if you have these deductions, to incorporate that into the back end of when you're reporting the sales to your landlord. And what we found is that these small items can really add up to big amounts.
Yeah, sure. I'm sure they can. And it's a brave new world after the pandemic in so many ways. And this is just another example. It used to was you wrote a check to your landlord every month and you were happy to have that money and make your profit on your dry cleaning store or bodega or big box apparel store, whatever it was you were selling. Life is not so simple. And we've come up with, and your firm helps people with, a more nuanced, let me put it that way, rather than complicated, nuanced way of dealing with it that is fair to both. The object here is that the landlord and the tenant may not recognize this, but they are partners. They're not adversaries. They both have an interest in the success of both their properties. That is to say, the landlord wants the store to make money and pay him rent, and the tenant wants the landlord to be able to pay his mortgage and otherwise take care of his building and maintain it so that he can run his business. They're in it together. If they recognize that, they're going to get farther along the road to being profitable and satisfied with each other. And one of the things that they both have to worry about is Local Law 97, which is what?
And I actually love I love the title of your podcast, Andy, and I also love the title as it applies to this topic here, at least in terms of percentage rents. A problem into profit, and the problem sometimes, or at least during the pandemic, and sometimes kind of generally, is the percentage rent. And from a tenant perspective, you don't necessarily want the landlord to be excessively profitable. The tenant doesn't recognize this, but they have a problem with the percentage rent. And part of what we do for any client that comes to our law firm and our perspective is that our clients need to be profitable after they retain our services. So if a tenant is paying a percentage rent or has a prospective percentage rent or was paying a percentage rent, we turn that problem into profit by showing them these are generally accepted deductions, or these are deductions that should be or are in your lease. And then here's how you implement them when you're on the ground. And that makes a tenant and a business more profitable.
We're here to serve. That's what Coopersmith and Coopersmith does, is try to make life better for the people who come to them with questions and problems, right?
I think any attorney deep down really wants to help their clients. That's certainly our perspective, and the perspective of our law firm. And we really do want to make our clients profitable and empower them with both information and knowledge to do so.
And that's both for the landlord and the tenant. You know, the landlords get a bad rep. They're snidely whiplash and they're ruthless and heartless. And that's not the case. They're just another businessman, no different than the commercial tenant who is renting the space from them. They're in it to make a living and to stay stable and continued in business. They're not there to run anybody out of a town on a rail, and nor to not succeed in their effort to maintain their property and their business. Now, you had mentioned earlier before we started that you had something to add for tenants and commercial landlords with regard to Local Law 97. Is that something you want to share?
Sure. Local Law 97 and also tenant improvement allowance. So we talked a little bit about pre-pandemic, how commercial tenants and commercial landlords were affected by percentage rent and lack of volume. I think just kind of before tackling Local Law 97, I think that it's important to address market conditions, strain on commercial buildings, how interest rates have increased, and what it means for landlords and tenants. So landlords, a lot of landlords have an underlying mortgage. They're going to be refinancing. One of the reports I was reading is that if you want to have a healthy building, and the way the banks see it, is that you need a debt service coverage ratio of 1.3, meaning that the income from the building to the debt of the building, the mortgage, that ratio is 1.3. In order to sustain that now based off of the current interest rates, you need to basically be, if you're refinancing, be at essentially a 1.9 ratio. So you need to be an extremely healthy building to refinance at current rates as they are now. But of course, there's a lot of strain on commercial rents. Tenants aren't necessarily signing long-term leases or taking as much space as they need to. There's a flight to quality in terms of Class A buildings and the buildings that commercial tenants are going to. And so it's more difficult from the landlord side to refinance a building and to find quality tenants. What that means from the tenant side is that if you are induced to sign a lease and there's a tenant improvement allowance, which you're banking on to take potentially higher rent than what's out there, a rent that is higher than what's out there for subleases, you want to make sure that that tenant improvement allowance is paid to you. And what are the mechanisms that a landlord is going to ensure that that tenant improvement allowance is going to be paid to you? There are a few. There's an SNDA, a subordination, non-disturbance, and adjournment agreement, trying to get that signed by the landlord's lender. If the landlord is healthy, and if you're a larger tenant, that's easier to secure. But there are also other mechanisms, like being able to apply it to rent coming due, potentially a guarantee from the parent company of a landlord, and a lot of others that we don't necessarily need to address in this podcast, but that there are mechanisms out there that will protect commercial tenants.
And we are grateful. Well,
Right.
And they are too.
Right.
I think one of the things that's obvious from listening to you today, Hal, is you know your business. And it's funny how often clients can just tell that from the first conversation. When somebody knows what they're talking about, they're confident and clear, just as you are today, with the fundamentals, and whatever new unexplored question is going to come along, the client can be comfortable that you and your colleagues are going to be able to face it and resolve it.
I appreciate that, Andy. We've certainly had a lot of these conversations with residential landlords, as we mentioned, with ResQ, informing the real estate community in terms of the obligations of the Housing Stability and Tenant Protection Act. I mentioned that this law came out in 2019. In the pandemic, when residential leasing in New York City was not as hot of a commodity, and you actually had empty streets and people leaving the city, and rent stabilized, apartments listed on the market, something I never thought I would see in my lifetime. We were informing the community about the obligations of the Housing Stability and Tenant Protection Act. And we saw a lot of these problems, again, real estate problems, coming down the pipe, and certainly began to your point, know our business and know the problems around that. With respect to commercial landlords and commercial tenants, yes, we saw a lot of these problems as well, and appreciate the opportunity to speak with you about them, to continue to inform our clients and the real estate community about the issues at hand.
Anything else you want to add?
This has been a wonderful podcast. It's great to see you, Andy, and you've had on a lot of wonderful guests previously. I certainly looked at the other episodes, so I'm grateful to be here.
Well, I'm glad to see it too. And you know what? For those people listening carefully, they want to know what the hell is Local Law 97, just so we can tell them before we leave.
Right. So third time's a charm. You asked that question 3 times. That might as well answer it. Local Law 97 affects energy emissions in New York City, and it was a law that was passed a few years ago. And the goal was to try to make New York City as close to carbon neutral as possible by 2050.
And people do not appreciate the tremendous impact on the climate of large apartment buildings.
Right. Apartment buildings and office buildings, all buildings in New York City. I think that it accounts for approximately 2/3 of greenhouse gases. And there was actually just a very interesting article in the New York Times that this isn't just energy efficiency, it's greenhouse gases. So those letter grades that you see on buildings are not related to local law 97. And just because a building has a certain letter grade doesn't mean one way or another that it is affected by um, uh, uh, what it means for local law 97, rather. So a grade is about consumption of energy. It includes electric and water. But local law 97 is about greenhouse gases, CO2. And to the point of the New York Times article, that there were new office buildings coming online that have great energy efficiency, that preserve water consumption, generate electricity, but but aren't great with greenhouse gases because now enemy number one is natural gas, and you see that with stoves and talking about gas stoves, trying to reduce greenhouse gases. So energy efficiency and greenhouse gases don't necessarily correlate. Why I bring this up is because, to your point, Andy, co-ops and condos, as well as office buildings, need to get in compliance with local law 97. Penalties measurement is beginning January 1st of next year, January 1st, 2024. So buildings, if they haven't already, they're a little bit late in the game, but they need to start getting into compliance. There's a shorter period of time where the threshold is lower, then the threshold's going to increase. And what's important, if you're in a co-op or condo, understanding what your building's local law 97 plan will be, and how that's going to affect your maintenance and assessments. And smaller buildings are not affected by local law 97, but larger buildings are. And if you're a commercial tenant, or certainly a commercial landlord, you want to know the same thing as well. You just don't have other shareholders or board of directors to account to necessarily, like you would in a co-op or condo. But you need to get your building into shape. And with respect to commercial tenants, you want to understand what your obligations are under your commercial lease with respect to local law 97. Certainly try to carve out some items and figure out what a plan of action would be.
And you're there to help.
We're there to explain obligations on the tenant side and the landlord side. And certainly from a tenant side, if you're negotiating a lease or in the process of negotiating or renewing a lease, local law 97 is a law that is on the books right now. So your plan for a renewal or a new lease should include knowing about this law. And that should be priced into your lease as you negotiate as kind of your best strategy, rather than waiting for a lease to come through. But if a lease does hit our desk, we're certainly on the lookout for local law 97 obligations.
And this continues our theme of this evening, that the business partners are just that, partners in the effort of maintaining a healthy, profitable building and the businesses inside it. The landlord and the tenant are working ideally together to be successful. Hal, let people know before we leave how they can get in touch with you so they can get all these questions answered.
Wonderful. Well, our website is coopersmith.law, Coopersmith, COOPERSMITH.law, in terms of that's what we do. I mentioned ResQ. It's our proprietary platform. Go to rescueme.com, REZCUEME.com. Enter code Weltchek at checkout for free use. We're going to cap it for the first 20 people who do it. Enter code Weltchek, just as an appreciation for being here today. And if there are more fans, please reach out, and we're happy to give more complimentary uses.
It's always a pleasure to chat, Hal. We look forward to continuing it. Thanks to everybody who's watched. We hope you found it helpful. I know I have. And with that, we'll go to the outro, as they call it. You have been listening to Real Estate Problems into Profits with me, your host, Andrew Weltchek, a partner with Cohen Hochman Allen Attorneys at Law in New York City. Thank you for your positive reviews, comments, and sharing this show with others. You can listen to prior episodes on www.chalegalteam.com and on YouTube, LinkedIn, Apple Podcasts, Spotify, Google Podcasts, and more. Thank you.